all, thank the organizers of this act in the person of Professor Luke Moffat for the kindness of the invitation, which gives me the occasion to visit Northern Ireland for the first time and to share with you some reflections on the subject matter which unites all of us, gathers all of us here this morning. This is a subject matter of the utmost importance nowadays, and I would like to focus my presentation on my own experience in dealing with it. Everyone speaks for his or her own experience, and so will I. I have had the privilege to serve two international jurisdictions which are quite different. One in the domain of the international law of human rights in the American continent, and the other with an interstate mechanism for the settlement of contentious cases. And I will attempt to draw on cases which have brought into the fore some aspects of this subject matter which might be of interest to you. So may I start with the experience of one of the human rights courts, making also cross-references to the European Court of Human Rights as well, with which I am also very familiar. I've been accompanying its work for the last 25 years steadily, and have had the occasion this year to make a presentation in Strasbourg for the opening of the judicial year of 2014 on the question of compliance with judgments, including reparations. But may I start with my experience in the handling of cases, in particular referring to reparations in the Inter-American Court. Since that court started operating in the late 70s until now, it has been marked by different cycles of cases. The first cycle of cases was the one concerning enforced disappearance of persons. That marked the earlier years of the court and led to some jurisprudential developments of great importance also for the issue of reparations, which I'll refer now. The second generation of cases, so to speak, is more concentrated on the question of due process of law and undue delays, such as marks the great bulk of the case law of the European Court on Articles 5 and 6 of the European Convention. Anyway, these cases were very similar to the ones brought before the Strasbourg Court. Then, from the last decade onwards, I had the occasion to adjudicate those cases, the cycle of massacre cases, on which I will also concentrate some of my remarks. But let us start from the very first cycle of cases. I remember when we were handling the cases on enforced disappearance of persons, we had three key countries in which this happened. First in Honduras, and then in Guatemala, and subsequently in Peru, and very recently in the internal armed conflict in Colombia. But in the first difficulty that we had to face was the complex nature of such breach and the question of reparations for it, Because when there is a breach, then there comes the obligation to repair the breach. These are two faces of the same coin, the breach and the duty to provide reparation. One cannot separate one from the other. Separation would be absolutely inadequate to handle breaches. And this, you find this in the very origins of the Law of Nations. Already the founding fathers of the Law of Nations, they referred to the duty to provide reparation. The duty to provide reparation is a reaction of the international legal order to a breach of that order, so as to seize the effects of the breach. So in this first generation of cases, I will not refer to all of them, but only to the paradigmatic ones. We had to determine the question of the victims, which I have been told is a key question to you. I am not familiar with the situation of Northern Ireland. I'm very honest to say that I'm trying to learn, but I'm not familiar, so I'll concentrate on the cases with which I have been familiar. So these cases of disappearance, particularly in Guatemala, proved to be crucial. There were 626 massacres in the period from 74 to 86. The Guatemalans set up a commission on verification of historical facts, and they ended up by concluding in a very commendable way, because they themselves concluded that the targeted group was always the same, the Mayas, which form a majority of the population, and amongst the Mayas Ashi. And therefore, they had the characteristics of a genocide, because there was a targeted group. So they themselves reached this conclusion. Now, what about the question of reparations? One of the great difficulties which they found in the question of disappearances was the determination of the amount of reparations, because one did not know the whereabouts of the disappeared persons, and therefore there were cases of justiciability also, because the question of the competence to deal with such cases was not very clear. But then we had a great challenge to face and to overcome. The determination of the notion of victim in such cases. Was the victim only the disappeared person, or the notion of victim encompassed also those very close to the disappeared person? And since it was a complex delict, then after a long discussions, I remember this in the mid-90s, we came to the understanding that the notion of victim is somehow enlarged in relation to the protected rights. That is, the disappeared persons are deprived of their life. There was a presumption of their having been deprived of their life. We know that the European Court took much longer to reach a similar understanding. It had to wait until the cycle of cases concerning Turkey and the cycle of cases concerning Chechnya to form the same understanding as the Inter-American Court did a few years earlier. But we made the precision that the violated right is different. So, the disappeared persons, they had presumably the right to life violated, arbitrary deprivation of life. But that right might not be justiciable because the state at issue only recognized the competence of the court later. But those who suffered tremendously and continue to suffer for not knowing the whereabouts of the disappeared, they are also victims of other rights. Of, for example, the right not to be subjected to cruel, inhuman, or degrading treatment, of right to personal integrity, and so forth. I'm still referring to the first cycle of cases, the cases concerning enforced disappearance of persons. So, how to focus on the question of reparations? There formed in the inter-American system an understanding that just one form of reparation would not be adequate. Unlike the European Court, which until the early 80s only provided for compensation, pecuniary reparation, the Inter-American Court started very early to consider other forms of reparation, such as the ones that Dr. Moffat mentioned a few minutes ago. Restitutio, if possible, in the case of disappearance, is impossible. Compensation, satisfaction, rehabilitation, and guarantee of non-repetition. Why was this possible to do this under the American Convention in the American continent? It was possible because the drafting of the provision on reparations, Article 63, was different from the drafting of the provision on reparations of the European Convention. The European Convention referred to just reparations, satisfaction équitable. And this was understood from the very beginning as meaning pecuniary reparations. But the draftsman of the American Convention said compensation and utilized the conjunction, the additive conjunction, and other forms of reparations. And this proved crucial to consider all these forms of reparation mentioned by Professor Moffat well before Bassiouni and others drafted the Declaration of 2005. I mean, the UN Declaration of 2005, which was quoted here a few minutes ago, was the object of a jurisprudential construction of the Inter-American Court 15 years before they concluded this UN declaration. So it's also supported by international case law. It's not only, so to speak, legislative instrument of the United Nations. It has strong, this is of interest to you, I suppose. It has strong support in international case law as one of the sources of international law. So when we started examining in the mid-90s, these cases of disappearance for the purpose of reparation, we started thinking immediately of distinct forms of reparations for the next of kin, for the close relatives, or for surviving victims, or moral damages and material damages in relation to the fatal victims, to this disappeared person, or to the fatal victims. And at the end, I can tell you, at the end, we were faced with the need to decide on the basis of equity. Equity is another source of international law. It was an equitable consideration on the provision of reparations. let me just open a parenthesis for 2 minutes and refer to the very first case of reparations that we had concerning Suriname. It was not a case of disappearance, but of extrajudicial execution of 7 persons for having been suspected of being subversives against the regime in Suriname. And they were made to dig their own cave, and then they were shot and they fell into their graveyard. The state acknowledged its international responsibility, so the court moved straight on to the stage of reparations. When it moved to the stage of reparations and we started to hearing from the next of kin, we found out that the 7 killed persons left 17 widows because of the polygamy which prevailed in that community in Suriname. So we are faced with, well, facts are always much richer than the law. And we are faced with this difficulty. So we sent our deputy registrar to Paramaribo to talk to eminent persons there to see whether this was recognized in domestic law, and so it was. It was recognized in the Constitution itself, and then we came to the conclusion that they were all entitled to reparations, even if they got married again, but they were entitled to reparations. So we put reparations in the social context, attentive to the cultural practice of the community at issue. And this was particularly important. I remember that it was a very difficult decision to take. Another one, which is in my book of memories, which I passed on to Professor Moffat, referred to the question of reparations for the next of kin, for other rights, as I mentioned a few minutes ago. And then we had to consider, well, what if we haven't yet heard of the mortal remains of the person? In one particular case, they were found shortly after the decision on preliminary objections, before the decision on reparations, and just before the decision on the merits too. But then we came to the conclusion that although a person who dies ceases to be a legal person from the standpoint of theory of law, for the purposes of succession, it still has its effects, and therefore it has to be considered likewise for the purpose of reparations. So these cases proved to be very important for beginning to construct this case law. Now, I wanted just to make a point that for cases such as those of extreme violence, of disappearances, and I haven't yet reached the cases of massacres, which in a few minutes' time I will dwell upon. Reparations do not put an end to what occurred, not at all, to the violation of human rights. The wrong has already been committed, and the wrong is not effaced by reparations, not at all. In such cases, the damage done is irreparable to the next of kin. But what reparation does in such cases of grave breaches of fundamental rights, what reparation does is to avoid the aggravation of the consequences of the damage done. That's the importance of reparations. How these consequences may be aggravated? By means of the indifference of the social milieu, by means of oblivion. This does not exist. I mean, we have seen cases of extreme violence which they have an intergenerational projection. They are not forgotten. but the reparations are meant to alleviate the suffering of those who are also direct victims in their own right, close relatives, but also to put an end to consequences. So, reparation may be understood as being a reaction in the realm of law to human cruelty, manifested in the most diverse forms, and an attempt also, with the rise of international criminal law in recent years, from the 90s onwards, to put an end to the impunity of those responsible for the breaches. So, this is the proper scope of it. For instance, in the second generation of cases that we had, cases concerning due process of law, I remember having interviewed victims of torture. And I saw some cases in which they decided to live abroad, not to go back to their home countries. I have created my own conviction that torture is also an irreparable harm. A person who has been tortured will not be the same again. This person tends to lose faith in the others. I mean, it's really a very cruel harm, the harm of torture. And to some extent, it is irreparable as well. We can try to find ways to alleviate suffering, and I'll come back to that in a short while. Still in relation to this second generation of cases on due process of law, we developed the idea, which is closer to civil law than to common law countries, of obligations of doing. And this was particularly in cases of reparations that were ordered as prestação social, as social services. In the case of tortured persons, we ordered a couple of respondent states to pay for the studies of those who had been tortured, to pay for their education or their sons and daughters, since as from the time they were tortured, they could no longer have the energy to pay for themselves, to develop their own project of life. So this was a particularly important stage of the development of the case law. I am totally in agreement with the point which has been made by Professor Moffat a few minutes ago as to the victim-centered character of the whole application of international law of human rights. I mean, I regard the development of international law of human rights as probably the most important legacy of international legal doctrine from the second half of the 20th century. It is built on the premise of being victim-oriented, so to balance the imbalance which exists between the state and those subject to its own jurisdiction. But of course, the panorama is much more complicated when we come to a situation of an internal conflict, armed conflict. And here, we have convergences between the international law of human rights, international humanitarian law, and more recently, from the 90s onwards, also international criminal law. And we are still in the infancy of this last stage of development with the inputs of international criminal law. Living nowadays for the last 6 years at The Hague, I can feel that. In The Hague, we live in a kind of feudalistic system with different international tribunals. Each one takes care of its own garden, and there is not much interaction between the different tribunals. Everyone is overburdened with work in his or her own tribunal, and so we have a very fragmented view from what happens a few yards away from where one is. We only have a voluntary meeting of judges from different tribunals in the month of June, end of June, and it's on a voluntary basis. I always attend these meetings as I'm very interested in the inputs from other international tribunals. But here we have a difficulty, how to approach international human rights law, public international law, international criminal law, international humanitarian law. For example, international criminal tribunals, they are concerned essentially with international individual criminal responsibility. While the court I have the honor to serve nowadays is concerned with the determination of international state responsibility. But in my view, the two complement each other. They cannot be approached in an atomized way, especially in relation to grave atrocities, to grave violations, and to cases of particularly violent armed conflicts. Another important legacy of the cases of disappearances, coming back to the first generation of cases, was the question of the right to truth. This was a difficult one to tackle because this very concept of the right to truth started being developed later than the adoption of instruments such as the European Court and the European Convention and the American Convention on Human Rights. But there were elements within the two conventions that were taken into account in order to elaborate on the right to truth. And if I can mention one particular case, the case of Bamaca Velázquez concerning Guatemala, the first resolutory point of the judgment was a call to the respondent state to determine the truth of the facts of the case and to provide information on the whereabouts and the mortal remains, to find the mortal remains and to give them back to the family of the fatal victim. This was the first resolutory point. We decided to make it the first, and compensation only second, third, fourth resolutory points of the judgment. 2002, this judgment. It's very interesting. Now, I have passed the page. I'm now in another tribunal, but I can tell you, looking back in time, we have to look forward, but we have to look back in time as well. What I have found in the adjudication of those cases is that respondent states, they are prepared to pay compensation. They don't have much difficulty to provide payment for, as compensation, pecuniary reparations. But what they have difficulty of is to investigate the facts and to sanction those responsible. We have had cases already decided 10 years ago, and we still don't know exactly what happened. We still don't know the responsible ones. The facts have not been disclosed, although compensation has been provided. I'm very sad about this. This is part of the experience of the court I used to serve. And I will also refer to two cases which I consider paradigmatic, which have been brought now before the International Court of Justice. But before doing that, I wanted to turn to the most recent cycle of cases, the cases of massacres, which began to be lodged with the Inter-American Court, more or less at the same time as the Turkish cases were lodged with the European Court. I'm not referring to the African Court because it's quite recent. I mean, it started operating in 2006, so that's why I'm referring to the other two, the European and the Inter-American. Now, in relation to the European Court, it made a change, and I spoke with some of the counsel for the victims that appeared in Strasbourg. I spoke with several judges. Some of them are my friends that participated in this case. They decided to follow a path similar to the ones that we followed in the Inter-American Court when they stated in such cases, especially in the early 90s onwards, that if there is no investigation of the facts, then there is a procedural violation of the substantive rights at issue. So this was a very important new approach adopted by the European Court in Strasbourg from the 90s onwards, which is similar to the one that we adopted in the Inter-American Court from the cases of disappearances onwards. Why did we manage to adopt this case? Because we have two general obligations: the obligation to respect and to ensure respect. And this obligation to ensure respect means positive obligations on the part of the states to investigate and to take any other action which is necessary to explain what happened and to sanction those responsible. Now, the cycle of cases of massacres, especially in Guatemala and in Colombia nowadays. I mean, in Colombia nowadays, one case after another. They have provided with one difficulty, an additional one. The exact amount of victims, it's not clarified, and the identification of those victims. I remember these cases, this corresponds to my last 5 years in the Inter-American Court, from 2001 to 2006-07, which the alleged victims themselves, they said, we don't want our names to appear in the application, in the complaint lodged with the court for personal security reasons. So I remember that in the hearings of those cases, I used to ask the following question during the hearings. Are the victims or the alleged victims at least identifiable? And then normally the legal representative of the victim said, yes, they are identifiable. For example, peace communities in Colombia, they organize themselves so as to protect themselves from the ongoing internal conflict by issuing their own ID cards. So they would be identifiable even if they don't want to be identified before the International Tribunal, the Inter-American Court. So we decided in these cases to adopt the criteria that victims are also the identifiable ones, not only the identified and also the identifiable ones. And then we took an unprecedented step of including a provision in the judgments, for example, Mapiripan, the case of Mapiripan, which will be of interest to you, the case of Ituango, Mapiripan and Ituango, 2006. We said, any other persons who claim to be victims of the atrocities as established in this judgment may present themselves to the competent national organ of the state concerned and prove before this organ that they were victims for the same facts that were alleged in the complaint brought before the Inter-American Court. And then the state concerned would be under the duty to provide the same types of reparation which were provided to the other victims already identified. So this was unprecedented, the criteria of identified and identifiable victims. And until now, except for one case, it has not been questioned. But in this one single case in which it was questioned, it's because two persons had identified themselves, but the facts were not the same. And so this was amended afterwards before the competent national organ. So in this example, the institutions at international and national level, they cooperate. I mean, there is an interaction. There is an interaction between the international legal order and national legal order. It's not an atomized way, a compartmentalized way of saying international separated from the national. No, they are interpenetrating each other, national and international. Given the pitiless pressure of time is never sufficient. We could spend the whole day here discussing this. It is a very important subject. I will just refer to two extremely important cases that, surprising as it may seem, have been lodged with the International Court of Justice, which is for interstate cases, but they concerned what happened inside the states. One is the case concerning the terrible regime from 1982 and 1990 in Chad of Hissène Habré, a dictator, which left 40,000 victims, 80,000 orphans, 30,000 widows, and 200,000 people left with no moral or material support as a result of the repression of the years 1982 to 1990. He escaped from Chad and sought to hide himself in Dakar, in Senegal, and he took resources, public resources with him. He had some of the most expensive lawyers to assist him in Dakar, and then, as a party to the Convention Against Torture, Belgium sued Senegal for not having applied Articles 5 and 7 of the Convention Against Torture and initiated proceedings a long time ago against him. So this case, I'm sure it's well known to some of you or to most of you, if not all of you. But those who have not read it, please have a look at this, because it shows the question of the temporal dimension of damages without reparation. And the need to put an end to the consequences of those breaches. The gravity of the breaches admitted no further prolongation of the situation of undisclosure of what actually happened and the lack of due reparations to the victims, numerous victims. The allegation of the previous government of Senegal was that they did not have funds to start a judgment, but the African Union put pressure upon Senegal to find an African solution for an African problem. And then, with the support of the European Union, I am summarizing it because we could speak for hours about this case, but with the support of the European Union, the African Union and the European Union got the funds, and now they have started the pre-trial arrangements for the judgment of Mr. Hissène Habré. If this judgment really takes place, it will have been the first time in modern history that the principle of universal jurisdiction will have applied. And it marks, in my view, the importance of the search for restorative justice, because one point made by the victims, they are already victims according to the UN Committee Against Torture, is that for their rehabilitation, they need this trial, they need justice. It's not the unveiling of truth only, they need justice, they insist on justice. So the passing of time does not efface, it even aggravates the resentment of what happened. They had detention centers where they tortured people on a day-to-day basis. It was terrible what we have seen in the hearings in this case. And the most recent one is this case here concerning the Diallo case, which concerns arbitrary detention and expulsion of foreigners. And this person, Diallo, became creditor of his state of residence, Congo. He is a national of Guinea. And Guinea brought the case on the exercise of diplomatic protection. But once the case was there, they both started arguing on the basis of the United Nations Covenant on Civil and Political Rights, and on the basis also of the African Charter on Human and People's Rights. So on the basis of human rights instruments, they changed the basis of their argumentation. It was fascinating. And so they drew attention to the fact that although the mechanism was an interstate mechanism, the titulaire, the bearer of the right to reparation was the individual concerned. That was unprecedented in the history of the International Court of Justice. And there I had the occasion to make the point that the centrality is the victim itself, herself or himself. The victim holds the centrality. The victim is the justiciable, is the one who is seeking justice. And there is an indissoluble whole between breach and reparation. One comes with the other. One cannot separate one from the other. Reparation is a fundamental obligation, victim-oriented. And all this has been a concern in human thinking, coming back to my first words, since the very beginning of the Law of Nations, the principle of neminem ledere, not to do harm to anyone. Once harm is done, it's the legal order itself which is breached, and hence the duty to provide reparation. Thank you very much for your attention. Thank you.
Time is ticking with regards to victims here in Northern Ireland and more generally. I wonder if you would talk a bit about at what point, for instance, are grandchildren deemed victims, or at what point can we draw a line and to say, well, these individuals are, for historical reasons, are no longer victims? Thank you.
Thank you very much for your question. This point, in fact, was brought to the attention of the Inter-American Court in the case of these 3 children. And then we indicated, not in the resolutory points, it's not there, but it is in the course of the reasoning of the judgment on reparations, which is of 2001, that when we refer to next of kin, we refer to ascendants or descendants of the immediate generation. Otherwise, and as you know, this has been much discussed as well in one of the world conferences of the United Nations, the Durban Conference, of the United Nations on racial discrimination, the question of slavery, and so we consider that the immediate ascendants and the immediate descendants. And thank you for the point which gave me the occasion to make this precision.
Is there another quick question? I'm very conscious of time. Does anybody have a quick question at the front?
You talked about the centrality of the victim to reparation. How important is it that the victim actually informs the type of reparation to the healing and the consequence to the rest of the community to move forward, in your opinion? I know it's a big question.
Thank you very much for your point. I think it's extremely important that this is brought to the attention. For example, in this case which I summarized as much as I could of the Seine-Abré tragedy, in Chad. Now, it was from 82 to 90. Do you know how long it took for them to get organized? Until mid-90s, they organized in association of victims of the dictatorship of Seine-Abré. Then they only managed to bring their case to the UN Committee Against Torture for a decision on 2006, almost a decade later, and they brought this to the attention of the Committee Against Torture, saying that that was an aggravating circumstance. And then they only managed to bring the case before us, the International Court of Justice, in 2009, and we decided in 2012. And only now they are beginning the pre-trial phase, which may bring them some justice. That's why I mentioned, in my opinion, separate opinion, that I find that the time of human justice is not the time of human beings. Vita brevis, the life is very short, and human justice sometimes is too prolonged. It's unjust. Thank you.
Thank you. Thank you, everybody. One more question? One more.
Kieran McAvoy, I work here at Queen's. Judge, you said something very interesting at the start of your talk. If I heard you right, you said that for you, victims of torture in particular, that torture is almost irreparable. And in this society, we've had people who were tortured by paramilitary groups, tortured by the state. We've also had women who were subjected to years of domestic violence, and which probably would constitute torture as well. So we've had a lot of people in this community who have been the victims of torture. Would you just expand for us a little bit about, I thought that the word irreparable seemed to me like a very strong word in terms of the consequences of torture.
From what I learned from my own experience, now I'm referring only to my own experience, having spoken to some of those victims, have visited, once I visited one in prison, I spoke to them, and the impression that I had is that a person who undergoes this mistreatment, as I mentioned very briefly, loses the faith in human beings. It's very difficult to set up new human relationship with new persons that this person meets throughout life. It is a very cruel breach of human rights. I find it a grave violation of human rights in the technical sense. No? It's particularly grave violation of human rights. And it is also included in the corpus juris of international criminal law, as you know, and also in international humanitarian law. Nowadays, it's recognized everywhere as a grave violation which admits no kind of restrictions. I mean, one cannot justify torture in any circumstances whatsoever for that harm which is done, irreparable in that sense. But of course, there is a duty to alleviate suffering of those who have been tortured. Thank you.
Okay, thank you. No more questions. The judge will be here, so will, for the next session, and will be floating about in the workshop, so do feel free to approach him and ask any questions that you have for him then. We now want to welcome our local practitioners, our experts, who know very well the experience of trying to get justice, to get some sort of remedy here in Northern Ireland. So I'd just like to give you a round of applause to the judge once more.